this will be framed as a variation. That comes from the sort of the culture, I suppose, where you don't want to make a claim per se. You will make, a variation, and you will agree on terms for variations. And that is why I think this is becoming more relevant, because when it comes to prolongation cost claims, you might think, well, it's going to be a breach of contract. Actual cost should be the rule in terms of valuation of prolongation cost. But no, actually, in North Africa, most of the time, it's valued on the basis of rates. And you would have rates in the contract dealing with whether it's a day work rates or in Africa as well. I mean, I'm currently involved in some projects funded by the EU, and you have rates in the BOQ dealing with prolongation costs, time-related costs on a monthly basis.
In the new Green Book as well, there is an interesting, so the FEDI Green Book is a short form of contract, and in this new Green Book, there is an interesting provision to value the prolongation cost, and there is a kind of formula which is proposed just to simplify and to spare the hassle of having some claim experts, and so there is in the contract, in the general condition, a formula to assess prolongation costs. So it depends on the time when the claim is made. So whether or not, if my memory is correct, the claim is made during the first half, the first 35% or the second 35% or the last stretch of the contract. There is the formula, the parameters will be different. There's a calculation of the overall estimate of the overheads, and therefore there will be a calculation of the daily overheads. And considering the time when the claim is made, using this daily assessment of the overheads, there will be, and considering the duration of the prolongation cost, there will be a formula which will give, I would say, so to speak, automatically an amount of prolongation cost. So an interesting feature.
Just probably one point in terms of legislation, the German legislator has some 4 years ago, adopted this system of cost plus for variations, for real variations, as a kind of default rule. That's the first thing. The second thing, however, is if you, and it shows and demonstrates how tricky it is, if you omit an item and you have a BOQ rate which is low, and then you omit this item and the rate will not apply. Now you extract something new, go for cost plus, the contractor makes real benefit.
You are exactly stealing my point about omissions, because when we deal with variations based on rates, very often I'd say, I don't want to take side, but the employers will say, well, it's too high. These rates are too high. They don't reflect actual cost. Well, those rates apply to both parties. If you were to omit some works, you would omit works on the basis of the same rate. So if they're too high, then it would benefit you as well. So I think that the idea of having rates to value variations, including prolongation costs, I think is very good, because a very large part of the dispute relating to variations comes to that. Whether it's a variation or not, but ultimately it's all about money. So it's all about how much do I pay for this extra works. If we were to agree on rates and the time impact, time-related costs, then you would have a lot of this dispute that would actually go away.
Well, frequently you can also really save costs. Under Red Book, for instance, an engineer could sometimes, under 412, just instruct a variation using very low rates and interpolate the new rates from them, while under normally 412 you have to pay costs, which could be even higher than including profit of the rate. So you can play games, right?
Could I just call you out on that? As you've used a term that you used during your presentation, intrapolation, extrapolation. Would you be able to distinguish that for our audience who might not have English as a first language?
Similar rates, and you may derive easily from one of those a kind of a new rate by looking just of the developments, or extrapolate. You will have to go and to compare the various matters in order to then come to a conclusion based on broader data. It's just slightly different approach to the same matter. Basically, you derive a new one from the old one.
And I'm just conscious of the time. I think we need to wrap up. But I think the final point was about, I think, And that's something that has been covered before, the payment of the variations. And one of the issues that we face in Vietnam and other jurisdictions, the fact that very often there's a need for the employer to have a contract amendment in place before a payment is made, not unique to Vietnam, be assured. And that creates difficulties in a way of financing the varied works. I mean, you mentioned, I think, 18 months before a contract amendment is signed. I can tell you in Nigeria, it's about 3 or 4 years before you actually get your contract amendment, and therefore you can actually get paid. And on really large, oil and gas project, you're looking at a shortfall of something between 50 to 100 millions every year of shortfall of cash for the contractor. And then there was another point this morning about what would you do? Well, what would you do? You would make a claim for the shortfall, and that would be typically the financing charges you would actually claim for the shortfall of cash for 3 or 4 years. But obviously, it's not the ideal solution. Solution would be obviously that there would not be the need for a contract amendment for the payment of variations under the contract, or if there's one, obviously it should be done in a much shorter period.
Well, that's certainly been one of the most dynamic panels I've had the opportunity to moderate. I've got some time allotted here for questions from the audience. I think there's a roving microphone. I'm going to hand up over here.
Practical solution.
Hi, this is in terms of claims, I mean, claiming for variations, extensions of time, additional payment, you name it, there are many circumstances. In your opinion, surely if you can demonstrate, let's say a contractor, for example, demonstrate cause, effect, substantiation, or provide substantiation and demonstrate entitlement, those 4 things, can a claim fail? Can it possibly fail?
Definitely. And in all these matters, when you change something, you must demonstrate that there is a consequence which directly derives from the change. And if you don't show the evidence, then basically, of course, the claim must fail. Contractors try to avoid that by arguing again, I have finally expended more money on the same job, and therefore, if you look at my cost situation, I need more money, please, that's my claim. But of course, that is no evidence for cause and effect. But I think Frederick had that.
Maybe shows I mean, I tend to work a lot with contractors, so I have very often this sort of argument, Sebastian, which is, has to be a very strict causation link in order for your claim to succeed. I think it's been more subtle because there are claims that are not simply the result of a variation and one effect. Very often is multi-variation, or one variation that would have multi-effects, and that's usually the case on very large projects. And a particular variation will impact the works in different ways, in different aspects of the site. So it may be actually really complicated to do that. One particular change will have that sort of effect. So you will have, of course, to have a method to demonstrate, and that's, again, burden of proof. And as an interesting debate, we can talk about what is the burden of proof under Vietnamese law, French law, English law. On the English law, the burden of proof is about the balance of probability. More than 50% chance that the costs you've incurred have been the result of this. On the French law, and maybe that's the case on Vietnamese law, it's actually a lot stricter because it's left to the discretion of the judge or the tribunal, but it's certainly something that is, you need to show the causal link. But again, it's going to be left to the discretion of the judge. So with this discretion comes a bit more room for leeway, but certainly it's the causal link is usually the main issue in all arbitration when it comes to variations.
I would like to add one point because it makes it more practical. Basically, the contractor must first of all demonstrate expenditure. Expenditure means that the efforts which are needed in order to come to a certain result. And of course, it's related to cost. But the costs come from the expenditure, the efforts on site. And the contractors frequently even are not able to demonstrate what they have done on site, rather they just simply demonstrate that there is money involved. Okay, but for which reason? And that's something which you must look at before you go further. That helps a lot.
I mean, I can give you just one example at the moment. We were involved in a case where there was some security restrictions imposed on the contractor by the employer in terms of access to site. And every day, roughly, they were wasting about an hour and a half to 2 hours for the team to go on site. It's difficult to tell whether then they had, instead of 12 hours of work, they had 10 hours or 6 or 7 hours. What was actually the true performance, the reason why they only performed 8 hours of productive work every day. But what he had to demonstrate is the fact that there was these restrictions imposed, which is a different method, which is amounting to variations that has caused lost man hours. And these lost man hours can be valued on the basis of rates. And that is your variation. And this is how but you won't be able to demonstrate that a particular person came on site on this particular day 2 hours later because he was stuck at the vehicle checkpoint for 2 hours. It's just impossible when you have a team of 2,000 people going on site every day for 5 years. But there are ways to demonstrate your entitlement. And I think tribunals tend to recognize that sometimes it's just not possible to do this causal link so refined that you can show this impact. But left to the discussion of the judge or the tribunal.
We've got time for one more question. Do we have another question in the audience?
I would like to have a question for Didier. So in your speech, you say something like when there's variations under a project that is funded by provided the loan by ADB, so it will be subject to the review process whether to decide whether is comply with the principle, and ADB may give the objections into that in respect to that variations. So I have two questions. First one is that does it imply that there will be a prior approval review process before the variation, or furthermore any instruction under the project to be reviewed by ADB? And the second question is that if it otherwise that there's not such requirement that ADB should give approval in advance of every instructions or variation. So is there the consequence that at first the employer give a variation or they give notice for instruction, and then later on ADB during its review found out that it's not aligned with the principle, so they reject that kind of variation? So what will be the consequence?
I realize that perhaps I was not totally clear when I spoke about the objection or no objection by ADB to variations. Actually, we will not object to the variation itself. The decision to go for a variation will rest on the borrowers. However, we may have an objection on funding the variation. And we may say, well, when it comes to the reason or the rationale or the relevance of variation, we do not, we do not discuss this aspect, it belongs to you. But now we as a funder, so we object to funding this particular variation because it does not fit within, for instance, the grant or loan, I would say, overall amount. We usually have some contingency amount for price and quantity, but it may be that the variation will have exhausted, or previous variation have exhausted this contingency. So in that case, we will have a discussion with our borrower as to how we will fund the variation. But we will certainly not say, you should not do this variation. This is none of our, so to speak, it's not our remit or not our concern. We are not the one to dictate whether variation should be done or not, implemented or not implemented. But however, since we are the funder, we may object to funding it. And again, I mentioned various principles, whether or not it fits with the loan amount and loan duration, whether or not it will not, I would say, give rise to breach of integrity, whether or not it will not breach the eligibility principle, whether or not the variation will be will give rise to perhaps to a direct contracting, which would better be procured through a standalone contract. In that case, we may say, well, you want to make a variation, and I gave the case of a road, for instance, which was terminated under contractor A, and you say that you want to give the remaining works to contractor B. Now, in that case, we say, well, we consider that this road will be, these remaining works will be better procured with a fresh contracting, a fresh bidding. Well, in that case, you may say it more or less tantamount to object to the variation as a variation itself. But we will rather, well, in that case, we will discuss with our borrower, try to agree on the best way to procure these remaining works to be done, either under variation or perhaps under fresh bidding. But we still have the principle that as per our policy, the implementation of contract, the responsibility rests with our borrowers. So it's not for us to dictate whether a variation should be implemented or not. This is my point I wanted to.
Yes, in order to make give a bridge to what was said earlier about a contractor who claims money which is presumably not present. Well, I've recently given an expert statement on a contract worth roughly 200 million, and for a tunneling project where the supports were in the employer's requirements under dimensions, and that the soil was totally different. So we were already halfway at about 80 million of additional work for the tunnel, which means that IDB would have more normally terminated everything, because you can't do that, because the money will not be present usually, because you have a 25, probably whatever, contingency, but such high amounts basically not.
So in that case, however, in that case, there would be several options. We, however, do exercise flexibility. First, we will explore if the borrower could perhaps self-finance this excess of work. We may consider to have some what is called additional financing. Perhaps we may encourage the borrower perhaps to engage discussion with other MDBs. But well, it may be that in fact we could decline, and in fact should the funding for some reason be, I would say, maxed out, or we may decline, and therefore then it will be left for the borrower. And in that case, to answer your question, we for large variation, it does in terms of internal procedure, we escalate it to a high level. We have a procurement committee who make high value, would say, decision, and we do give a prior approval for variation. But usually we have discussion. It's not black and white, and we, of course, we will not jeopardize a project we have funded. If there is a shortage of cash or funding, we'll try to find a way. I can't give, I would say, a definitive answer for all cases, but of course, the fundamental objective is to get the project done.
We started a little bit late, and I would hate to eat into our time, but certainly, if you have any comments to add to that.
Maybe on that point, I think the lack of financing is sometimes relied upon as a ground for suspending the works. I think this was mentioned earlier, and I think that can be a powerful tool, not about termination, because I think it's been more risky, but certainly suspension when you have asked for evidence of financing in place for significant variations, or when you have a determination of the engineer that actually recognize the contractor's entitlement to payment, and no payment is there, then obviously insisting via letters to show the evidence can be a ground for suspending and maybe trigger then a payment. So I think it's it's a powerful tool.
Perfect. We've run through all of the I may just allow one more question if it's a short question, because as I said, we did start a little bit late.
It's a short question, but I think quite complicated question about the choice of law. I think it's a question to Didier, but I think Dr. Locke or Frédéric, maybe you can also complement the question. As ADB members are coming from common law countries or civil law countries, how do you handle the or how do you see the landing for the construction of the project? What kind of law do you recommend when they do that? Another question to complement to Dr. Locke and Frédéric. I'm sure you have made some analysis between the civil law system and the common law system and the impact on the construction law. So if you could give us some outline for Vietnam. Vietnam is a civil law country. So if you can give your opinion on the law of construction in Vietnam. Thank you.
First question, allow me to perhaps to avoid to skip it, because actually I'm not in the legal department of ADB, the Office of General Counsel. My understanding is that our funding agreement do not refer to a governing law. We do not have our, if my understanding is correct, I think it's related, I think it's, we have a privilege of immunities, and I believe that we do not, our funding agreement are not based on a specific governing law. But however, this is not my remit, it's my remit of my colleague from the Office of General Counsel, so I rather not to elaborate too much on it.
Well, my view, we have done, by the way, I have done some years ago a kind of survey on that matter in Hanoi for ADB. And my view was at the time that all these constraints which we have seen today, Decree 848 and this particular law number 11 and so on, they of course exist, but are they all mandatory, compulsory, or could it be that it is simply gap filling and default rules, and the contract anyway prevails because that's what the parties have signed? So I'm not much impressed by these rules, because in all former communist countries, I've seen similar things, a very dense amount of regulations everywhere. And you can't really expect that in a world where finally you tender, you will have to look at everything here and there. Rather, you may finally have to agree on something which is written in your contract. So again, in French law, we do have mandatory compulsory law. There is no way to deviate from that, decennial and subcontracts and so on. You may also have sometimes here and there something we have discussed, for instance, here in Vietnam, the question of payments without taking over. There's a kind of commission to be put in place and to approve things before money can be released to a contractor. Do we really need that for each particular IPC? Do we need a taking over for each IPC? I finally said no, because this is stupid. It's not in the interest of even the employer, because it will mean that you hand over something, there's care of the work shifted, you will have a lot of problems with delay damages and so on. So it doesn't help anybody. So my view was, it's not really always compulsory.
And can I give you my 2 cents on that? Because I've been asked that question before. And really depends on where you sit. If you are acting for, or you are the contractor, or the employer, or the subcontractor, you may have different interests in the applicable law that will be applied to the contract. Typically, English law, in general, will give far more certainty to the employer, usually mandates the terms of the contract. So I would tend to say, and that obviously for public works, there may be other considerations that would require Vietnamese law to be the applicable law, but otherwise, acting for the employer, you just go for English law, give you certainty that lots of things you can actually achieve which are in the contract. You don't have to look for what is the applicable law really in terms of the civil code, for example. So I think that's the typical thing. Currently doing a project in Korea, private works, French contractor, but in Korea, we're going for English law because it's certain. Acting for the contractor, you may think, well, actually, quite like to get civil law because I've got we didn't talk about good faith here, but obviously good faith and all the ramifications that comes with that principle are far-reaching and gives a lot more comfort to contractors, and whether you are in the Middle East, in Europe, particularly when it comes back to time bar argument that may be thrown at you. So I think, contractors tend to prefer a civil law applicable law. And then when you're a subcontractor, obviously you want to make sure that you have the same applicable law throughout, because if you have English law in the main contract and then another applicable law in the, that creates a mess. So I think having consistency throughout makes more sense. But if I can be allowed 1 minute of publicity, just to answer that question a bit more, we're launching an LLM course in Singapore in January on international construction contracts. It can be attended remotely as well, and this is a 1-year course, and that will explore precisely the comparison of common law and civil law for international construction contracts. If anyone of you is interested, just let me know.
And at that point, my watch starts buzzing. Look, we work in a fascinating industry. It doesn't really matter where you are in the world. We deal with fascinating problems, and we try to find fascinating solutions to them. But thank you to the SCL Vietnam for hosting us. If you have any other further questions or just want to cross-fertilize ideas, our panel will be available afterwards. Thank you.